Today we are discussing chapter 18 of Cr.PC. Chapter 18 of the Criminal Procedure Code. It deals with trial before a court of session. Section 226 of Cr.PC states that the prosecutor shall open the case by describing the charge brought against the accused and must also state by what evidence he proposes to prove the guilt of the accused. If the accused refuses to plead guilty, the court may, on the application of the prosecution, issue a process for compelling the attendance of any witness or the production of any document or other thing as per section 230 of Cr.PC. Under section 231 of Cr.PC, on the date fixed, the judge shall proceed to take all such evidence as may be produced in support of the prosecution. The provisions of sections 230 and 231 of the Cr.PC referred to above do not indicate that the issue of process for compelling the production of any document or other thing is confined to any document produced along with the final report. ഫൈനൽ റിപ്പോർട്ടിനോടൊപ്പം സമർപ്പിച്ച ഡോക്യുമെൻറ്റിൽ ഒതുങ്ങി നിൽക്കുന്നില്ല. അതിനുശേഷവും ഡോക്യുമെൻ്റ് സമർപ്പിക്കാം എന്നാണ് പറയുന്നത്. സിമിലർലി ദ എവിഡൻസ് ടു ബി അഡ്യൂസ്ഡ് മീൻസ് തെളിവായി ഹാജരാക്കുക. ഓൺ ബിഹാഫ് ഓഫ് ദി prosecution need not necessarily be confined to those produced along with the final report. The terminology used in sections 230 and 231 of the Criminal Procedure Code indicates that the prosecution is entitled to produce any document supporting the prosecution evidence. Though generally the documents and evidence are those that are collected during investigation, the prosecution cannot be tied down to only those documents produced along with the final report. If an important document or a witness has been omitted or was not produced for whatever reason it may be, the prosecution cannot be denied an opportunity to bring it on record as a piece of evidence in the trial. In the decision in Central Bureau of Investigation versus R.S. Pai and another, the Supreme Court had observed that the investigating officer is required to produce all the relevant documents at the time of submitting the charge sheet. The court also held that, however, there is no specific prohibition that documents cannot be produced subsequently, and that if some mistake is committed in not producing the relevant documents at the time of submitting the charge sheet, it is always open to the investigating officer to produce it with the permission of the court. എന്തെങ്കിലും ഡോക്യുമെൻ്റ് ഫൈനൽ റിപ്പോർട്ട് കൊടുക്കുമ്പോൾ വിട്ടുപോയിട്ടുണ്ടെങ്കിൽ ഇൻവെസ്റ്റിഗേറ്റിംഗ് ഓഫീസർക്ക് കോടതിയുടെ സമ്മതത്തോടെ അത് ഹാജരാക്കാവുന്നതാണ്. It was also observed that if further investigation is not precluded under section 173 of the Criminal Procedure Code, there is no question of not permitting production of additional documents which were gathered prior to or subsequent to the investigation. Under case, similarly, in the decision in Rajendra Prasad versus Narcotic Cell 1999-6 Supreme Court cases 110, while dealing with the question on what is the lacunae in a prosecution case, the Supreme Court observed that if proper evidence was not adduced or a relevant material was not brought on record due to any inadvertence, the court should be magnanimous in permitting such mistakes to be rectified, since the function of a criminal court is administration of criminal justice and not to find errors found by the parties or to find out and declare who among the parties performed better. Yet again in P. Chaganiel Daga versus M. Sanjay Shah, the Supreme Court held that even after the arguments were heard and the case was posted for judgment, the complainant can move the trial court for the reception of additional material in exercise of the powers under Section 311 of Cr.PC. The power under Section 311 of Cr.PC is of the widest range, as held by the Supreme Court in Mohanlal Shamji Soni versus Union of India and another. With the above principles in mind, when the circumstances arising in the instant case are considered, it is evident that the prosecution alleges that due to the act of the accused, the victim became blind and accused is being prosecuted for the offence under Section 326A of IPC. The certificate of the medical board indicating 10% blindness of the victim was obtained only in 2016, and this document was not known to the investigating officer or to the public prosecutor. It was only after the trial was completed that the victim handed over such a document to public prosecutor. The nature of the crime alleged and the nature of the certificate sought to be produced by the prosecution indicate that the same is essential for a just decision in the case. In this context, it is necessary to refer to a recent judgment in V.N. Patil versus K. Niranjan Kumar and others, 2021 3 Supreme Court cases 661, wherein the Supreme Court had observed that the trial court can exercise suo motu powers in summoning witnesses whose statements ought to be recorded to subserve the cause of justice with the object of getting evidence in aid of a just decision and to uphold the truth. The scope and purport of Section 311 of Cr.PC are quite often misunderstood. It is a provision enacted for the purpose of aiding the ultimate object of a criminal trial, that is to render justice to the parties. There is no embargo or restriction in summoning any person as a witness, even those witnesses whose statements have not been recorded earlier, or to accept any material. The only restriction is that the material or the evidence sought to be adduced must be essential for a just decision in the case. The contention that the document was not seized earlier or that it was not part of the final report is not a relevant consideration in a proceeding of this nature, since the learned sessions judge has found that the evidence sought to be introduced in the form of a document and to examine the doctor who issued the certificate is essential for a just decision of the case. I find no perversity in the impugned order. Accordingly, this criminal miscellaneous case is dismissed. Okay, read this judgment carefully and take the important points therein. Okay, thank you.